We're going to use Ben Franklin's words to start off this video. In one of our prior videos, we mentioned the famous quote from Ben Franklin that says that nothing is certain except taxes and death. We turn now to death in this video and how property passes to your beneficiaries. Chapter 19 of our book, Next Gen Dollars and Cents, includes a discussion of the pertinent legal documents that you should have, plus the tax implications when someone passes. Of course, the reality is no matter how much you plan, you'll never fully appreciate the emotional toll that someone's passing has on their loved ones. It certainly is a difficult time that can unfortunately be made far more emotional if things are not set up the way that they need to be to pass efficiently and effectively. So the first key concept to understand is how property passes. And there's actually three ways in which property passes. It's by operation of law, it's by operation of contract, or it is through a will. So three very unique concepts that we're going to discuss. Each of those transfer methods has very different estate planning implications. So the first one, by operation of law, is this notion of transferring property at one's death by the automatic reassignment of ownership according to legal principles that don't require any particular specific action or agreement between the parties. So when property passes to someone by operation of law, it's passing based upon how that asset is titled. So the transfer is automatic, regardless of what's stipulated in their will or regardless of what they might otherwise have intended. There's no room for debate when something passes courtesy of operation of law. And there are typically four sort of registrations that you typically see, each one of them having very different implications. The first would be an asset that is titled in an individual's name. That's going to pass by operation of the will because that is solely in that individual's name. The other type of registration you might see is a joint tenancy with rights of survivorship. That is when two or more people own a particular asset, and upon the death of any owner of the ownership group that owns that particular asset, it passes to the remaining owners automatically. So if three people own a property with rights of survivorship and one passes, then that property will become owned by those remaining two people automatically, no matter what other document exists. The reality is that this operation of law concept will trump anything else. Tenancy in common is another option that allows for two or more owners to have an unequal interest among them. Each person then owns a separate and distinct interest in the property. So each owner's respective share, should they pass, the passing of that will actually be governed by their will. And then lastly, a tenancy by the entirety, that is reserved for married couples where if one passes, the total ownership of the asset passes automatically to the spouse. Now, so that's the primary ways in which property passes by operation of law. The second option to transfer property is by operation of contract. So that process involves naming beneficiaries directly in maybe an asset's title or an account registration. You can do this by adding a transfer on death registration or a payable on death registration to certain types of accounts. You can also name a beneficiary on an account as well. Those types of operation of contracts basically serve as a legal agreement between the account owner and the holding institution that is, of course, legally binding. At the death of the owner, the property automatically passes to the named beneficiaries. And those beneficiaries you can name as primary beneficiaries or contingent beneficiaries. Primary beneficiaries are the ones that sort of first in line to own the property. Contingent beneficiaries are second in line should there be no primary beneficiaries if the owner of the asset has passed away. I think the most important thing to remember is that naming beneficiaries on any asset allows it to pass directly to those beneficiaries without having to go through the probate process. And then lastly, the third option of how you pass property is by operation of will. A will is a legal document that specifies how a person's assets are to be distributed after their death. And what most people don't realize is that if you have a will, that is in fact the part that will be going through probate. That's the purpose of the will, is to provide a guide print for how the assets are supposed to be paid out to the various beneficiaries. Beyond a will, there's obviously other estate planning documents that are typically recommended. These would include a power of attorney, which is a legal document that grants someone else the authority to act on your behalf in certain legal financial matters. There's a healthcare surrogate, which is another legal document that appoints another person the ability to make medical decisions on behalf of yourself, often referred to as a medical power of attorney. And then a living will, of course, covers those more limited medical decisions relating to end-of-life care and wishes. Another document that you hear people talk a little bit about, and I want to spend a couple minutes on this, is trusts are sort of a totally kind of separate and distinct animal, if you will. A trust itself is a contract that details specific terms regarding holding property for the benefit of an individual. So assets passing to a beneficiary under a trust do so by the concept of operation of contract, because after all, that's what a trust agreement actually is. The trust document itself outlines the various terms and conditions under which the trustee manages and distributes out the assets. One of the biggest things is to make sure that any assets are titled in the name of the trust in order to make sure that they are under the umbrella of the trust. Trusts can take a couple of different variations, either being revocable or irrevocable. Revocable, perhaps the most common, created during one's lifetime, and it allows the grantor or the creator of the trust to ultimately change that trust so long as they are living. Common misconception is that revocable trusts protect against any liability or creditors of the individual setting up these trusts. Unfortunately, that's not the case during the course of the lifetime of the individual who set up that trust, because the trust still remains revocable. It's only when that individual passes and that revocable trust becomes irrevocable that you get that creditor protection, because an irrevocable trust, as the name suggests, can't be modified or revoked or changed. So because of that, then it does provide that protection against creditors and other legal claims that may apply to the beneficiary. So I think the bottom line on that is that irrevocable trusts are very rarely seen during the course of someone's life. So you want to make sure, given that you can't change it, you want to make sure that that before you, if you were to engage in an irrevocable trust, that you understand the real ramifications of that approach. Trusts certainly serve a valuable function in overall estate planning. They provide control on how your money is managed and distributed to your beneficiaries after you pass. But many times, trusts are used sort of unnecessarily when you may have more cost-effective means of transferring property by naming beneficiaries, establishing co-owners on an account, titling a property or adding beneficiaries is usually a sort of a no-cost transaction, versus doing a trust can sometimes be expensive. So make sure that you're really exploring the best possible, most cost-effective option when it comes to passing assets to beneficiaries after you pass. To be clear, though, if you have concerns over the behavior or decision-making skills of your beneficiaries, then obviously putting some control over your money in the form of a trust makes some sense. Hence, the word trust is actually you use a trust when you actually don't trust someone to properly take care of the money. Now, in terms of some of these issues involving passing and death and estate planning, well, once again, Ben Franklin's comments come back into vogue because even in death, you might have to worry about taxes as well. So two categories of taxes can apply on a transfer of assets from one person to the other. The notion of gift taxes, that is taxes that could apply on a gift given during one's lifetime. Estate taxes are imposed on assets after an individual passes. In the U.S., under the federal tax code, estate and gift taxes are combined into a single unified tax credit that basically translates to nearly $14 million for the year 2025. So very rarely do you see this coming into play because it means effectively that during one's lifetime or at death, every person can effectively transfer a total of nearly $14 million in assets without having to pay any estate or gift taxes. And the reality is the state taxes, or at least federal estate tax rates, are north of 40% and apply to your taxable estate, which again is that portion above that 14 million. Given that number, as you might imagine, less than 0.1% of all estates pay federal estate taxes, but it's certainly an area that is ripe for discussion as the folks in Washington kind of look for ways in which to adjust the tax code to raise more money without raising income taxes. This estate tax rate and exemption could very well be one of those areas that we hear a lot of conversation about over the years ahead. Now, gifts can be made during the course of one's lifetime, rarely trigger any taxes, particularly given that $14 million sort of unified credit amount. But know that you can also give up to $19,000 to any individual in the year 2025, and that is the annual gifting exclusion. And that number doesn't even include direct payments that you might make to a medical provider or to a undergraduate college type of institution. Now, one of the critical distinctions between gifting during one's lifetime and sort of transferring property at death involves the cost basis treatment for a particular asset. As we discussed in our prior video on taxes and in chapter 16 of our book, a cost basis determines the amount of any gain or loss from the sale of an asset that must be reported on one's tax return. At death, the cost basis on an asset will jump up or step up to the value at the time that that person passed. When you're giving a gift, the person that's receiving the gift during the course of your lifetime assumes the basis that you had on that. So just know that there's a little bit of a different tax treatment on the subsequent sale of that asset, depending upon whether you inherited that asset or whether it was given to you during the course of your lifetime. So obviously a full range of topics here when we start talking about estate planning, along with the emotional and financial impact of what happens when a loved one passes. So having an effective plan in place can certainly make that transition smoother across the board. It also makes sure, if you have an effective estate planning, that your property passes and is transferred according to your wishes, and any expenses are minimized on that. The bottom line on all of this is to make sure that you take the time to do your homework on planning your estate. But make sure you take full advantage of all of those available options to pass property to others effectively. For much more details on these various estate planning concepts, we encourage you to read chapter 19 of our book, Next Gen Dollars and Cents. You can get your free copy of our book by texting free copy to 407-791-0070. That's 407-791-0070. My name is Joel Garris, certified financial planner, certified financial fiduciary at Nelson Financial Planning, and author of Next Gen Dollars and Cents. Thanks for watching this video.